In light of the circumstances of this matter, the committee recommended that respondent be suspended from the practice of law for 6 months with no period of deferral. Respondent filed an objection to the severity of the sanction recommended by the hearing committee. So wait, do I read this correctly? He had a recommendation for a 6 month suspension, and so he has objected to that?
Ooh.
So what do we have here? We have something from the Supreme Court of Louisiana for immediate news release. I don't know exactly what that means in the legal context. The opinions handed down 30th day of January 2019 as followed. Upon review of the findings and recommendations, hearings committee, disciplinary board, considering the record, briefs, oral argument, it is ordered that Felix Anthony Dejean, 4, Louisiana Bar Roll number 25028 be and hereby is suspended from the practice of law for a period of 1 year and 1 day. All costs, expenses are assessed against respondent, etc. So let's see what's going on here. Now, first of all, a year and a day is a special number in bar suspensions because most of the time, I'm assuming it can vary from state to state, but from my experience, most of the time, any suspension 1 year or under means you automatically are reinstated. Any suspension of a year and a day or more means you have to petition for reinstatement. So on a year and a day, you file your petition does not mean that a year and 2 days you are back to practicing law. It means a year and 6 months or however long it takes the disciplinary board to then respond to your petition to be reinstated, to hold any hearings about your reinstatement, to conduct their character and fitness examination at this new level, to then reinstate you months later. So it could take 6 months to a year, an additional time. I'm assuming this varies, and I don't have a lot of experience with it, but this is my understanding, is that it's going to be a year and a day plus a petition to reinstate this person. So why would an attorney receive such a suspension? Let's find out. This disciplinary matter arises from formal charges filed by the Office of Disciplinary Counsel against respondent Felix Anthony Dejean for a attorney licensed to practice law in Louisiana. Before we address the current charges, and this is the part that you don't necessarily see highlighted in the articles that you read about this, if you've seen this elsewhere, is that this person has had a disciplinary history before. We find it helpful to review the prior disciplinary history. After being admitted to practice of law in 1997, respondent's first encounter with the system occurred in 2006 when he consented to a 2-year period of probation imposed by the disciplinary board for physical altercations and behaviors caused by his bipolar disorder, attention deficit hyperactivity disorder, prior use of marijuana and alcohol. As a condition of probation, respondent and the Office of Disciplinary Counsel agreed that he would execute a 2-year contract with the Judges and Lawyers Assistance Program. Respondent successfully complied with his obligations under the contract, and in November 2008, the ODC notified respondent that his probation was concluded. In December 2009, respondent was twice admonished by the disciplinary board for failing to properly address fee disputes with clients. Then in April 2010, this court accepted a joint petition for consent discipline and publicly reprimanded respondent. The misconduct issue there involved allegations that respondent relied upon false representations of his client and failed to verify the identity of the parties who appeared before him for the purpose of executing a notarial renunciation. I'm not sure exactly what a notarial renunciation is, but some kind of renunciation of something in front of a notary, I guess. So failed to verify identity in a notarial circumstances. That's interesting. And then 2013, the disciplinary board publicly reprimanded respondent for engaging in conduct prejudicial to the administration of justice when he acted in an abusive and threatening manner towards the opposing party during a settlement conference. Respondent sought review of the board's ruling in this court, reaffirmed the board's ruling as correct. Against this backdrop, we now turn to consideration of the misconduct at issue in the present proceeding. On March 19, 2015, respondent was present in the chambers of Judge Kathy Johnson of the 7th Judicial District Court for the Parish of Concordia for a conference in a criminal case. Also present in the chambers were the District Attorney, Bradley Burdge, and the First Assistant District Attorney, Anne Siddall. At the conclusion of the conference, as the parties were leaving the judge's chambers, a physical altercation occurred. Mr. Burdge claims that respondent exchanged words with him, physically confronted him, and, quote, chest bumped him.
In front of the judge, essentially, in the judge's chambers.
At the conclusion of the party, as the parties were leaving the judge's chambers. So that means in chambers or at the door, there was a random chest bump, like just random, like
come at me, bro.
Like, okay, so there's a couple kinds though. There's like I when I first heard this, I thought maybe it was an excited chest bump, like hey, we did it, hey, but this was to an opposing attorney. Why would you would never really be celebrating with the opposing attorney, let alone that we barely even want to shake hands with opposing counsel sometimes, lest the client see it and think that we're all buddy with opposing counsel.
So he obviously was upset if they exchanged words. He doesn't like what happened in chambers. And so his response is to sort of threaten the district attorney and apparently, I guess, shove up against him, like puff out his chest and like jump at him. I'm trying to imagine this in my head.
Now, it's possible that it was just the district attorney's characterization of it, but I mean, I don't see any reason so far to not believe the district attorney that something like this happened. Plus, there were other witnesses.
And he does have a history of being reprimanded for being aggressive, right?
Yeah, that doesn't help his case. It definitely doesn't help his case. Respondent, who would be Mr. Dejean, respondent claims that Mr. Burdge instigated the altercation and that he acted in self-defense. He was subsequently charged with simple battery in connection with the altercation. A trial was held before a retired justice, sitting just for that case, it looks like. The state called the following witnesses. There's a bunch of witnesses. Respondent testified in his own defense. At the conclusion of the testimony, Justice Traylor found respondent guilty as charged of simple battery. In oral reasons for judgment, Justice Traylor stated that he found the state had carried its burden of proof beyond a reasonable doubt. To find otherwise would be to ignore the testimony of all the witnesses. After taking sentencing under advisement, Justice Traylor sentenced respondent to serve 6 months in the parish prison suspended and placed him on 18 months active supervised probation with special conditions. Among other conditions of probation, the respondent was required to submit to a psychological evaluation at his own cost and enroll in and successfully complete anger management training. Let's see, a suspended sentence usually means there's a sentence ordered, but not imposed, not practically imposed on you. You aren't hauled off to court. You aren't given a date to report to pretrial or incarceration services or prepare yourself for incarceration or anything like that. Instead, the judge sets a date in the future to come hear about your case again, and usually they drop the charges or drop the sentence if you've completed conditions in between. So I can give you some examples from my experience in traffic court. Someone might have been driving without a license, but they were in the process of trying to get their license back. Well, the judge might sentence them to something, but suspend the sentence, and then after the person finishes their requirements to get their license back, they come back and the judge drops the case, so then they can finally get their license back. But if they didn't do their job and get their license back, now they've got the punishment. So it's an extra incentive, you see, for the defendant to get the job done, because they get to have sometimes a clean record. If the judge is part of the suspended sentence, the judge then later drops the charges. So that's all sometimes by agreement of the parties as well. But that can be a powerful incentive. So that's what that means. Respondent sought appellate review of this conviction. The Court of Appeal denied his application, as did the Supreme Court of Louisiana. In August 2016, the Office of Disciplinary Counsel filed formal charges against Respondent, alleging that he violated the following provisions of the Rules of Professional Conduct. So these would be the lawyer charges. So he's a lawyer, so he's acted outside of his an additional body of rules, the Rules of Professional Conduct. And this would be Rule 8.4b, the commission of criminal acts that reflect adversely on the lawyer's honesty, trustworthiness, or fitness, and 8.4d, engaging in conduct prejudicial to the administration of justice. Respondent answered the formal charges and admitted that he was convicted of simple battery. However, he denied that he violated the Rules of Professional Conduct. Respondent maintained that he was not the aggressor in the incident with Mr. Burdge and reiterated that his actions were in self-defense of words and deeds by Burdge. This matter proceeded to a hearing in mitigation conducted by the hearing committee in August of 2017. Based on the evidence and testimony presented at the hearing committee made the following findings of fact. To establish a context for mitigation, Respondent testified that during the trial of his client on drug charges, after Respondent repeatedly referenced an earlier arrest of his client, to which Mr. Burdge objected, a mistrial was declared. The battery incident occurred in chambers 2 months later on a date which motions were scheduled to be heard. While in chambers, Respondent chest bumped Mr. Burdge, and as a result he was convicted of simple battery. For this misdemeanor conviction, Respondent was sentenced to 6 months imprisonment, suspended 18 months of supervised probation, and a fine. He was also ordered to complete anger management, to continue to take his prescribed medication, and to see a doctor every 3 months. Respondent completed the anger management program and complied with the required visits. Respondent also continues to see another doctor, a psychiatrist who has treated him for over 15 years every 3 months. Prior to his criminal trial, Respondent filed a civil suit against Mr. Burdge for damages arising out of the battery incident. Respondent described the suit as trying to claim his innocence in mitigation of his criminal conviction. That suit remains pending. Based on these facts, the committee found that Respondent violated the rules as charged in the formal charges in failing to conduct himself with dignity and decorum demanded of a lawyer. Respondent violated duties owed to the public, the legal system, and the profession, diminishing public trust and respect for the profession and the judicial system. Respondent's conduct was presumably intentional. He did not claim that he acted as a result of any mental impairment or substance influence. While Respondent's misconduct caused no actual physical harm, it did impair the public reputation of the profession and judicial system. In aggravation, the committee found the following factors: the prior disciplinary record and substantial experience in the practice of law. The committee did not recognize any mitigating factors. In formulating a recommendation for an appropriate sanction, they consider a specific case. In that case, Greenberg and Lewis, Mr. Lewis and Mr. Greenberg represented opposing parties in a bitterly contested succession matter. While appearing in open court for a motion hearing, they exchanged vulgarities, following which Mr. Greenberg grabbed Mr. Lewis's suit jacket and both men fell to the floor. Mr. Greenberg was subsequently convicted of the misdemeanor offense of simple battery arising out of the altercation. In response to the formal charges filed against both lawyers, neither of whom had a prior disciplinary record, the court suspended Mr. Greenberg from the practice of law for 6 months, with all but 30 days deferred, subject to his participation in an anger management counseling program. The court publicly reprimanded Mr. Lewis. At the other end of the spectrum is Esteverney. Mr. Esteverney became involved in an altercation with opposing counsel during a deposition. At some point, opposing counsel suggested to Mr. Esteverney that the two of them step outside and settle the matter man to man. Mr. Esteverney left the office and appeared a few minutes later with an unloaded gun, apparently threatening to kill opposing counsel. Okay. Finding Mr. Esteverney's use of a dangerous weapon created a clear potential for harm, and considering that he had previously been admonished for harassing and unprofessional behavior, this court suspended him for 1 year and 1 day. In light of the circumstances of this matter, the committee recommended that Respondent be suspended from the practice of law for 6 months with no period of deferral. Respondent filed an objection to the severity of the sanction recommended by the hearing committee. So wait, do I read this correctly? He had a recommendation for a 6 month suspension, and so he has objected to that.
Ooh.
After reviewing this matter, the disciplinary board determined that the hearing committee's factual findings are not manifestly erroneous, and that the committee correctly found respondent violated the rules of professional conduct as charged. The board determined that respondent intentionally violated duties owed to the public, the legal system, and profession by engaging in criminal conduct. Respondent's conduct did not cause actual harm, but the potential for physical harm to the person of Mr. Burdge was present. Considering the ABA standards for imposing lawyer sanctions, the board found the applicable baseline sanction is suspension. The board found the following aggravating factors are supported by the record: a prior disciplinary record, refusal to acknowledge the wrongful nature of the conduct, substantial experience in the practice of law, and the illegal conduct itself. In mitigation, the board recognized the following factors: full and free disclosure to the disciplinary board and a cooperative attitude towards the proceedings and the imposition of other penalties or sanctions. Turning to the issue of the appropriate sanction, the board surveyed the prior cases of this court involving facts similar to those at issue here and determined that respondent's conduct is most similar to the Greenberg v. Lewis or Greenberg and Lewis case cited by the hearing committee. However, the board felt this case involves more significant aggravating factors than were present in Greenberg and Lewis, primarily respondent's prior disciplinary history. The board noted that this is the third disciplinary matter in which the misconduct is related to respondent's failure to control his anger. Given this history, the board concluded that a 1 year and 1 day suspension with no period of deferral is warranted, as respondent will then be required to establish his fitness by clear and convincing evidence before returning to the practice of law, as I said in the beginning. Based on this reasoning, the board recommended respondent be suspended from the practice of law for 1 year and 1 day. 2 board members dissented and would recommend a lesser period of suspension. The board also recommended that respondent be assessed with the costs and expenses of the proceeding. Respondent filed an objection to the disciplinary board's recommendation. Accordingly, the case was docketed for oral argument pursuant to the Supreme Court Rule 19. Okay, they have another objection, right? Is that what I'm seeing? So there was another recommendation. This time it was for the year and a day. So it went from 6 months to a year and a day, and then there was another objection. Bar disciplinary matters fall within the original jurisdiction of this court. Consequently, we act as triers of fact and conduct an independent review of the record to determine whether the alleged misconduct has been proven by clear and convincing evidence. While we are not bound in any way by the findings and recommendations of the hearing committee and disciplinary board, we have held the manifest error standard is applicable to the committee's factual findings. In brief and argument before this court, respondent purports to accept the guilty verdict in the criminal proceeding, but asserts that he has not committed any misconduct, maintaining that Mr. Burdge initiated this altercation or that respondent acted in self-defense. Respondent's arguments are not supported by the record. Rather, the record demonstrates in clear and convincing fashion that respondent physically confronted Mr. Burdge and chest-bumped him during a conference in chambers. Based on these facts, respondent has violated the rules of professional conduct as charged by the ODC. Having found evidence of professional misconduct, we now turn to a determination of the appropriate sanction for respondent's actions. In determining a sanction, we are mindful that disciplinary proceedings are designed to maintain high standards of conduct, protect the public, preserve the integrity of the profession, and deter future misconduct. The discipline to be imposed depends on the facts of each case and the seriousness of the offenses involved, considered in light of any aggravating and mitigating circumstances. By its very nature, respondent's criminal conduct was intentional. He violated duties to the public, the legal system, the profession, causing actual harm to the profession and potential harm to Mr. Burdge. The sanctions in our jurisprudence in prior cases concerning attorneys who have engaged in violent conduct range from a period of suspension to disbarment. And they go over what looks like 5 cases here in a footnote. Let's check these out quick and see if anything is worthwhile. In Crabson, a man was backing his car out of a parking space at a Walmart store when he heard a car horn behind him. Unsure whether he had hit another vehicle, he got out of his car and walked around to check for damage. As he did so, Mr. Crabson exited his own vehicle and began screaming profanities. Mr. Crabson then approached the man and threw several punches at him, striking him once and leaving a bruise in his cheek. When the man's wife tried to separate them, Mr. Crabson pushed her away. Mr. Crabson subsequently pleaded no contest to simple battery. For his misconduct, the court suspended Mr. Crabson from the practice of law for 1 year and 1 day. In Bowman, the lawyer was convicted of domestic abuse battery following an altercation with his former wife. Specifically, while attempting to exercise visitation with his children, the lawyer pinned his former wife against a door, placing his forearm against her throat and chest. He also drew back his left hand in a fist as though he was going to punch her, but he did not actually strike her with his fist. For this misconduct, the court suspended the lawyer for a period of 6 months, with 30 days deferred, or with all but 30 days deferred. In Cardenas, Mr. Cardenas struck his estranged wife in the presence of their minor child. He was subsequently convicted of domestic abuse battery, a misdemeanor, and placed on probation. For this conduct, the court suspended him for 1 year with 6 months deferred, followed by a 2-year period of probation. In Willis, Mr. Willis was waiting with his girlfriend in a vehicle at the drive-up window of a fast food restaurant. Before their food arrived, Mr. Willis and girlfriend began arguing. A physical altercation between them happened, wherein Mr. Willis hit and grabbed his girlfriend. He poured beer on her and hit her over the head with the empty beer bottle. Mr. Willis was ultimately charged with 2 counts of simple battery, which charges were still pending at the time of the disciplinary matter. He was also charged with other professional misconduct, including neglecting a client's bankruptcy matter, failing to refund an unearned fee and unused costs, failing to return the client's documents upon the termination of the representation, and practicing law while ineligible to do so. For this misconduct, Mr. Willis was disbarred. In Sterling, Mr. Sterling kicked in the door of his girlfriend's apartment and then pushed and shoved her around the apartment. He was subsequently convicted of unauthorized entry of an inhabited dwelling, a felony, and placed on probation. Mr. Sterling was also charged with other professional misconduct, including failure to properly notify his clients of the interim suspension that followed his criminal conviction, failure to return a client's file after he was placed on interim suspension, and transferring a client matter to another attorney without the consent of the client. For this misconduct, the court imposed a 2-year suspension from the practice of law. By their nature, the cases in this area tend to be very fact-specific, making it difficult to synthesize any broad precepts. However, it may be said that in general, the severity of the sanctions depend on the intent of the perpetrator, the harm resulting from the actions, and the context in which the conduct occurs. In the case at bar, respondents' actions were unquestionably intentional, although they caused no actual harm to Mr. Burdge. The conduct occurred in a judge's chambers, but outside the view of the general public. Considering these factors, we believe the baseline suspension is applicable. The only mitigating factor present is the imposition of other penalties or sanctions in connection with a criminal proceeding. In contrast, the record supports the following aggravating factors: a prior disciplinary record, refusal to acknowledge the wrongful nature of the conduct, substantial experience in the practice of law, and illegal conduct. Of the aggravating factors, we must place particular emphasis on the fact that this matter is respondent's 3rd disciplinary proceeding since 2006, which involves overly aggressive or physically abusive behavior. These are not isolated incidents. Indeed, the trial court which presided over the criminal case expressed clear concern over respondent's mental state, as demonstrated by the fact it required respondent to submit to a psychological evaluation and successfully complete an anger management program as conditions of probation. Considering respondent's disciplinary history, we find it appropriate to fashion a sanction which is both responsive to respondent's current misconduct and which will protect the public in the future by requiring him to demonstrate fitness prior to being reinstated to the practice of law. Accordingly, we will adopt the disciplinary board's recommendation of suspension from the practice of law for 1 year and 1 day, thereby necessitating a formal application for reinstatement. So that is the chest-bumping lawyer that got suspended for a year and a day, and the only reason that they got suspended for a year and a day is so that the court or bar can require them to petition for reinstatement. They'll have to pass a character and fitness evaluation again and prove their fitness to practice law. And the reason why that was appropriate was because it was the 3rd suspension, not because it was just a chest bump. It probably wouldn't have gotten to this level if it was just a consensual chest bump. That still would probably be considered inappropriate in court, but it would be less likely to be disciplinary action at this level if it was just a consensual chest bump. This appears to be something more. It seems that there were several witnesses testifying, and that the court actually found, and the guilty plea or guilty finding or guilty verdict went unappealed, that Mr. Dejean's chest bump was a criminal act. So it going unappealed, that's record evidence for the disciplinary board or Supreme Court, I guess in this case, for the Supreme Court to find that the discipline was warranted. So he had a chance to get off with a 6-month suspension, and instead has a year and a day and has to reapply for the practice of law, and will only be able to do so after showing fitness to do so.
So my question to you, Leonard, is have you ever gotten so pissed off at opposing counsel that you've wanted to chest bump them?
I can't say that chest bumping is where I go with my feelings of aggression. Like, I'm not a physically aggressive person, but if I wanted to go there, I'm pretty sure it would be my hands or my feet. Like, I'd want to punch or kick someone. I've never felt I've never been compelled or felt any compelling feeling to chest bump somebody as a result of an altercation. I've occasionally felt a desire to chest bump somebody as after like some success or something, like, you know, the team worked together and, you know, hey, we chest bump each other. I've done that, but I can't say I've ever felt compelled to do it as an aggressive thing, or as a either aggressive or violent or bullying or intimidating or angry thing.
Also, the fact that it happened like as leaving the chambers, that when I think about myself, now maybe it's because I've never been before a judge. When I think about how I would feel being before a judge, there's this extra layer of like, you have this professional responsibility and duty, and you really don't want to get on the judge's bad side because they could make your life hard. And if you're leaving the judge's chambers and then you want to get into a physical altercation, like I wish I knew what they were talking about. How do you get to that point?
And you never want to you never want to distract the judge from your client's case. This is even a stupid reason why I don't wear my earring anymore, is because I never want anybody to be focusing on that lawyer that wears the earring rather than my client's case. So I picture this chest bump thing. I don't know how it happened. Like obviously there isn't an agreement as to exactly how the chest bump occurred. So it kind of leaves it open to a little bit of interpretation. And, you know, without interviewing the parties involved, Mr. Burdge, et cetera, the district attorney, I'm guessing that since it happened as you're leaving, that you're kind of filtering from the larger room towards a doorway, and maybe the frustrated Mr. Dejean like sort of chest bumped his way past Mr. Burdge. Like they sort of like met at the doorway, and it was like, no, I'm get out of my way. Like, I'm mad at you.
So it's more like being rude rather than like come at me, bro.
I don't know. Now, I mean, it's a year and a day suspension, so maybe it was like a real come at me, bro, like violent thing, and not just like a little shove. I don't know. Certainly still inappropriate, even if it's just a little rude bump. Like, still inappropriate. So interesting. What do you think of that, my lawful masses? Let me know in the comments below. Thank you very much to our Patreon supporters who support this channel. This is a community-supported channel, and it is only possible because of the support that you guys give. Thank you very much. I'm Leonard French, your favorite copyright attorney. I will see you in the videos that drop and in our Sunday show on twitch.tv/lawfulmasses on Sundays at 10 a.m. Love you all. Bye.